Well, we lost the when you say it's a good
Good evening, everybody. Call to order a joint CFD work session of the Goodyear Community Facilities District Boards. This day, February 4th. Members of the district boards of the following community facilities districts, City of Goodyear, Arizona, will attend either in person or by telephone, conference call, or video communications. The following facility districts are called to order: Community Facilities General District Number 1, Community Facilities Utilities District Number 1, Palm Valley Community Facilities District Number 3, Stray Mountain Ranch Community Facilities District, Centerra Community Facilities District, Cortina Community Facilities District, Cotton Flower Community Facilities District, Wildflower Ranch Community Facilities District, Facilities General District Number 1, Wildflower Ranch Community Facilities General District Number 2, and King Ranch Community Facilities District. Roll call. Everybody is here. Chairman Kavanaugh, we probably need a motion to, or we don't need a motion, it's a work session, but Chairman Kavanaugh is, I'm sure, enjoying some very, very cold weather in Idaho, given the weather we're having down here, but hopefully he's getting good snow.
He just got there.
Just got there. Hopefully he's able to dig through the tunnel of snow to get to his place. So on this evening's agenda is an update and discussion on possible CFD bond issues and proposed new community facilities districts. And I believe Mr. Lang got the floor. It's all yours, sir.
Okay. Thank you, Vice Mayor Antoniak and members of the council, or excuse me, CFD board members. Purpose of this discussion this evening is to update the City Council on CFD financing, impacts of the changes in the real estate market, and impacts and changes in the financial markets. We have a couple of speakers who are scheduled to speak with us tonight. Larry Given from Peacock, Hislop, Staley and Given is going to discuss market conditions, and Scott Ruby from Gust Rosenfeld is going to discuss the legal fundamentals and credibility issues. Scott is here. Larry is not. I talked to a gentleman who came in from Phoenix today and said it took him an hour to get out here from Central, and
it's hailing right now.
Yes, downtown Phoenix is not good. So we're assuming Larry's on the way, but we'll probably jump Scott in order on this. Before we do that, I wanted to, if I could ask for Elmo, thank you. Wanted to show the City Council, I'll zoom this up just a little bit, charts of...
oh, you know what? Hold on, Larry, real quick.
Can we get a screen? I don't know what we're doing.
We're missing a screen over here. Fine.
You know what? Is it not something? There's some.
This isn't very bright.
Can I say one thing? As we're getting into the CFD issue this evening, I don't know what, I'm sure we can procedurally shift things around. Can we, if we have to, if they're not here? Rather than filling the void, we also have another work session following. So if we're just filling the void of time, let's
recess this meeting and go to the next meeting.
If we have to do that.
Okay.
So you don't feel like you have to, be a stand-in until Larry does get here.
10 o'clock tonight.
Right,
Oh, Larry,
exactly.
You're getting real boring.
Sorry.
Okay. I wanted to start with a chart that I think all of you have seen, but this is the single-family residential building permits by calendar year dating back to 2000. You can see it increased up until you get to the peak levels back in 2003, 2004, 2005, and has actually been decreasing for the last few years, a couple years. And so
That did not include November and December, or did?
This one did not include November and December. It was some.
Okay.
Although I think that number is pretty close. That might have included, and that chart didn't get updated for that fact. The real trend is that our single-family residential permits are going down, which is something that we've been talking about for quite some time. The existing annual pace that we're on, according to the Community Development Department, is considerably lower. It's somewhere, as I recall, in the area of about 750 permits per year. But at the same time, the activity that we are receiving in community facility district financings, and the interest in those financings is increasing. Last year, 2007, we issued 5 bonds for a total of $55 million. Those were primarily in the Palm Valley and Australia Mountain Ranch areas. Next week, we have on your agenda a $2 million bond issue for Centerra that they've actually been trying to get through for over a year. We had to put them on hold fairly recently as we were trying to get other debt issuances taken care of. And we have 2 more proposed financings at $28 million within the Australia Mountain Ranch area. In addition to that, we have 3 proposed community facility districts, which is just the formation of the districts and doesn't yet speak to specific financings. All of this is taking place at a time when activity, except for the commercial activity, is slowing down. So we thought it'd be appropriate with that backdrop to give you an overview of what the impacts are, because as you look at the CFD financings, while you might be told that issuing those is without risk, I think you're going to find tonight that there is an element of risk involved in CFD financing, and that as we go through this process, we should determine what that element of risk is that we are willing to accept. The 3 CFDs that are proposed at this point, one of them was talked about in the annexation process. Actually, I think 2 of them were. One is the area down, it's referred to as Amaranth, but it's the area down near Mobile. It's a portion of that area. We actually have an application in place. A second one is an area down, I think the southern boundary is on Patterson Road, called Madera, and they have discussed the formation of a CFD, but I think that's recently been annexed. And the third application is a small industrial property that we've got to, if that does come forward to the City Council for formation, we would have to waiver one of our policy requirements, which requires $100,000 a year property tax O&M. I have not discussed that with them. I have discussed lower levels of O&M with them as we've gone through that particular process. So with that, the City Council or the CFD boards will be looking at the element of risk that you expect to take and the special benefit that Goodyear receives by doing that. I would like to now ask, as I think, I'm going to ask Scott Ruby if he would come up at this time to speak on the legal fundamentals in that.
Mr. Vice Chair, members of the board, Scott Ruby with Gus Rosenfeld. And if I start to fill time, just throw something at me. So I'll try not to. I'll try to make this quick.
I've got about 20 pencils.
Okay. Generally, let's just a couple of other small, just fundamental points I think we want to establish. Number one, a community facilities district is a special district inside your community which can issue revenue bonds, assessment bonds, or general obligation bonds. Revenue bonds we have not issued because they need to be supported by some revenue, and of course the CFD doesn't own a water or a sewer service, and so consequently doesn't do that. Ad valorem property taxes are secure general obligation bonds, and the district does have the ability to levy a property tax inside the district only, which then secures the bonds. And lastly, there are assessment bonds, which are a specific dollar amount levied against a specifically benefited parcel, and you need to find that there's a benefit in order to assess the lien, the assessment lien against that property. So those are the 3 types of bonds. Larry mentioned the Louth project, which initially discussed the community facilities district, but also discussed an improvement district. And if I can just briefly, before Community Facilities District legislation was passed, cities and towns could establish improvement districts inside their boundaries. An improvement district has the capability of issuing assessment bonds only. So it was a process which is very similar to the process we follow in community facilities districts to issue assessment bonds. In fact, the CFD statutes actually incorporate some of those provisions of the improvement district law into their provisions, and so they're issued in a similar way. The key difference is an improvement district bond versus an assessment bond in a CFD is a contingent liability of the city. If for some reason the property owner does not pay their bill and the property cannot be sold and the proceeds of the sale used to retire the lien, the city is required to allocate out of its general fund that amount of the payment that's in default. Okay, so that's a contingent liability of the city, and so we've been in the past reluctant to use those. Generally, they're used for a single shot project, whereas we've used CFDs in the community here for master plan projects where we anticipate issuing both types of bonds, assessment and GO, and over a number of years, so as to accommodate growth over whatever 5, 10, 15, 20 years. So again, improvement bonds have been used for the single projects. I think we used one years ago up in the Business Commerce Center. It worked pretty well there, but we did have a default. We did have a bankrupt assessed parcel, and consequently the city did for a long period of time have to cover that assessment payment, and it at the time was not a small amount. But let me jump from that and then talk about the risks associated with land-based securities in general and how you all have allocated that risk and kind of tried to mitigate that risk in the past. And it's always a good, I think, a refresher sessions like this to look at those policies about risk mitigation in light of where we are now economically and where we are in the future, and looking back at the past to see what's worked and what maybe hasn't worked. As I mentioned, community facilities districts have issued general obligation bonds and assessment bonds. Those, because they're kind of a finite area of land, are land-based securities. And so general obligation bonds, although secured by an ad valorem property tax, when secured by a small area of land, it is a kind of a specialized issue. It's different from the city's general obligation bonds, which obviously would be secured by all the property within the city. So there is a little element of risk there that's different from a city GO. But generally speaking, they are much safer than assessment bonds because they are billed on the tax rolls and people pay their taxes, and ad valorem property taxes are kind of much more accepted than what you typically see or what you experience in the assessment bond. The lien of an ad valorem property tax bond is identical to the lien for general property taxes levied by the city, by the county, and everybody else. And if you don't pay, they're foreclosed in the very same manner. They're on the very same tax bill. So one of the ways we've mitigated risk in CFDs is we try to push on the GO side of the financing. We try to encourage them to make sure that they issue general obligation bonds, especially for those types of improvements which do benefit the district as a whole. If you're doing residential streets or smaller streets in more defined areas, we've said, no, why don't you use assessment bonds? But if you're doing the major arterials, the wastewater treatment plant, and the water facilities, which have a district-wide benefit, we'll try to encourage them. And in fact, your policies suggest to them that they should finance those types of district-wide improvements on a general obligation basis. So that's one way we've looked at general obligation bonds versus assessment bonds and tried to push as much of the financing, especially district-wide financing, as we can into that form of obligation. You've adopted policies, frankly. Way back in 1989, we adopted policies which have served us, I think, pretty well. We haven't had a default, and big default, let me put it that way. And it established a number of things. It talked about developers having to have a certain financial commitment to the project and equity contribution to the project. We talked about maximum tax rates in their maximum or minimum loan to or lean to value ratios for assessment bonds. We talked about who we would sell these bonds to and limited offerings to be sophisticated purchasers and that sort of thing. We talked about subsidy agreements where the developers for a period of time would want to subsidize the debt service because they didn't want to levy, in the case of an ad valorem tax that was so high that, it would be onerous upon the resident. So there's a supplement payment made by the developers, and we have a bunch of criteria there about what we look for in establishing those tax subsidy agreements. So first and foremost, if you want to revisit this or refresh yourselves as to what you've done to mitigate that risk, I suggest you look at your policies again, and I think you'll see in there quite a few safeguards which today and over the course of time seem to have worked pretty well. Another way we mitigate risk is we try generally to finance what we call acquisition projects as opposed to construction projects. You can sell the bonds early on and then put the proceeds in the bank, in effect, or with the trustee, and utilize them in the same way that you may do a city project, which is as the contractor submits their monthly invoice, you take bond proceeds and you pay those monthly invoices. That obviously has a construction risk associated with it. And the CFD really doesn't want to be in the business of building that street or that water line inside of a developer's community. That's a typical developer responsibility, and we try to leave it there. We as a city and as a district try to stay out of that construction process. Rather, we will tell the developer we will finance that public infrastructure. And mind you, the only thing we can finance with community facilities district bonds is public infrastructure. We cannot do private infrastructure like gas lines, utility lines that are owned by private companies such as APS and that sort of thing. So we tell them we will be willing to consider financing through CFD bonds that public infrastructure which you have publicly bid and which is completed. And we require a number of things to be submitted when they ask for reimbursement or, in essence, acquisition of that infrastructure project. Not the least of which is evidence that it has been publicly bid, evidence that it's been completed in accordance with the plans and specs as determined by an engineer and things like that. So that's another way we mitigate against at least the element of construction risk, is by acquiring projects as opposed to financing them early on. Now, we have gotten into some predicaments where we issue the bonds, even though they're acquisition bonds, with the expectation the project is going to be completed in the near future. And we have, in some instances, had to hold those bond proceeds for an unreasonable length of time. The Internal Revenue Code, the Internal Revenue Service, requires that you have a reasonable expectation at the time you issue the bonds that you're going to spend those proceeds, as a general rule, within 3 years, and including spending at least $100,000 of the proceeds within 6 months. So we enter into every bond issue with an expectation, reasonable expectation, that we're going to expend those proceeds within 3 years. We have had an instance or two where at the end of 3 years we still have proceeds in the bank because the developer hasn't finished the projects that we expected to be finished during that time period. So through the course of time, we get, and they have completed them ultimately, I will say that they've all passed muster eventually, but it causes us to have to yield restrict the investment earnings, if it increase or if it earns more than the bond yield, or rebate it back to the feds. And it also calls into question whether our expectations at the time of issuance were reasonable. The whole gauntlet of the Internal Revenue Code in that area kind of comes down on that. So we try to avoid that. And so consequently, we've tightened up that just from a practice standpoint, not necessarily a policy change, but we typically want to see all, or at least a very substantial majority of the improvements already completed before we issue bonds, or we want to see a construction contract already entered into and we kind of know it's proceeding towards completion. So that's one thing we do. Now, with respect to land ratios and land values, I can see Larry's here, so I can speed this up. That's the other area. We have, when we issue assessment bonds, the bonds are secured, in essence, by the value of the land. if the land has a value that come foreclosure time, if that unfortunate circumstance were to come about, has a value that exceeds the assessment lien, then it should be capable of being sold at a sale. And so what we generally say, what we say in our policies is, if you are going to sell bonds to the general public, the not sophisticated investors, but general public, we want a value of that land at least 6 times what the assessment lien is. If you're going to sell it to a sophisticated person like a mutual fund or an Allstate insurance or something like that, we want a value of 4 times the lien. And what happens in a foreclosure sale is if somebody doesn't make their payment, the entire assessment lien comes due and you sell for the entire assessment lien. And unlike a trustee sale like you have for your house, you don't give it to the highest bidder. The only price to be paid at the foreclosure sale of an assessment lien is the assessment amount. And so consequently, that makes them quite secure, because the assessment lien also wipes out every other consensual lien, with the exception of general property taxes levied by the county and the city. So it wipes out every lien, regardless of if that lien was before the assessment lien or after it. It wipes it out. So if I'm a purchaser and there's a $100,000 valued lot and there's a $25,000 assessment, I can go in and bid. I have to bid the full amount of the assessment. I bid $25,000. That gets me a $100,000 piece of property. That's how we want to make sure we're always going to have a market for people who are interested in buying those liens. It's been especially relevant recently because of the economic times we're in. And I think just in general, the fact that the CFDs are used more and more in residential communities which build infrastructure for starter housing, and starter housing now being, you define it, anywhere from 200,000 to 400,000 almost. We've seen a lot more, many more delinquencies in our assessment payments. And I know in your neighbor to the west, for example, we started this last December with 1,032 delinquencies. We're down now to 400 delinquencies, but they're moving through the process. The ultimate process is the sale of someone's home in order to secure the lien. So it's something that we don't like, we don't encourage, and those are liens, by the way, of $3,700 in many cases, $4,500 in some cases, on $200,000, $300,000 homes, but people are finding it difficult to make those payments. So we certainly have been okay from a lien to value perspective. When we go to sale, we have a lot of people in the room wanting to find that bargain. A lot of people. In fact, I had to preclude the city employees from bidding. But so in theory, that has worked. I mean, the 4-to-1, 6-to-1 kind of ratio has worked. And once you put a house on, it's even more. And more likely than not in those scenarios, I will add that we sell, in the end, we sell 8, 9 houses. And Goodyear's had some sales recently of houses also. But you whittle down from 1,000 something down to 8 for probably a couple of reasons. People kind of wake up and say, oh, I need to make that payment. But also, mortgage companies which lent money to build the home realize they're about to lose their collateral for their loan. So they come in and they make the payments. And then they deal with their debtor probably on more softer terms than what the statute allows us to deal with the debtor in the case of a foreclosure of an assessment lien. And mind you, you'd want to be as compassionate as you could be in that scenario, but we have bondholders out there who bought these bonds on the promise that we would follow the statutory process of foreclosure. And so we cannot deviate from that for risk or fear of the repercussions of what the bondholder might do back on the district. So that's an issue. So we try to maintain or make sure, at least going into the deal, that the land values are appropriate, that they do meet your policy levels. We obviously have put some restrictions or some requirements with respect to the appraisal, because we ask for an appraisal in each of those instances. For example, we want bulk wholesale value, which assumes that we sell because normally when you put the lien on, it's just they're all owned by a developer. We require that they look at what happens if we sell all these lots at one time. That usually depresses the market or depresses the value by anywhere from 15 to 25%. We asked them, once you arrive at that number, take another 5% haircut, because if we had to sell this large of a parcel, we'd certainly have to pay a commission. So we asked them to take that kind of haircut. We have them assume no development of the property except that which is financed either in the ground or financed by the bond proceeds. So you can't assume the golf course will be there or the lake or the amenities. We have them kind of appraise it as is. Even with all of those safeguards, when you hit a time like we've hit recently, you can watch your 4-to-1 ratio evaporate down to 2-to-1 in a matter of 6 months. So you have to be cautious in that area, and you have to be confident that not only is the raw value of the land what you expect under your policies at the time, but you also need to examine what's the quality of this development. Is it ongoing? Who is the landowner? Which really kind of gets to the next part. As another precaution, kind of safeguard, what we've done too is we look, and oftentimes it's contained in the appraisal, we'll look at some sort of absorption analysis or absorption of the project. Just as a general area, we'll want to know, how's this project stand relative to the competition? What's the demand out there, and that sort of thing. And again, all of those types of reports, and like an appraisal, need to be fairly current. So we can't operate on 8-month-old information, I think, where that would have you right now. So we ask, in instances we can ask, and if it's not adequately covered in the appraisal, we can ask for an independent absorption study. We look to the credibility and the sustainability of the owner. Now, not the residential homeowner, it never gets that part, or we don't ever take it that far, because you really are speculating on who that might be, but rather most of these deals are initiated by developers, and the developer is the one that is to sustain this project for a period of time until they do sell it to the homeowners. So we do look a bit at their credibility, at their experience, at their financial statements. The problem being, as you can well imagine, is they prudently put most of their projects into an LLC that's a single asset entity, so that the disruption maybe in one project doesn't affect all of their operations. So to look at a financial statement of a parent who's not obligated to pay the assessment lien, in one sense, is not directly relevant. What is relevant is their financial wherewithal to protect maybe their single asset entities and their reputation in the marketplace. So that comes into consideration. We don't have any specifics on that, but we are very careful in trying to make sure that the entity is one that hopefully will be around to pay the assessment. All that said again, and all of these precautions, never make a deal bulletproof. Example, Ingle Homes in Australia, we've been working with them for a number of, almost a year or two, on a proposed assessment district up in Australia Mountain Community Facilities District. But for some disagreement between them and Newland about what can be financed and how and that sort of thing, and what was financed by Australia or by Newland with the GO bonds, and what Ingle Homes wanted to finance with assessment bonds. But for some discourse there, we probably would have sold assessment bonds for their area and months ago. Well, as you know, their parent declared bankruptcy last week. And interestingly, their attorney said to me during the last 6 or 7 months, why are you not letting us proceed? Because we got wind that they were on the verge of bankruptcy. I mean, all you have to do is read the trades. That they were on the verge of bankruptcy, and we kind of put a stop to it. We said, look, till this situation clarifies itself, we're not proceeding with an assessment bond issue. It's not in our policies. It's just, it was discretionary experience by your financial team collectively, and we said, we're stopping with this. And, the response back was, why are you doing that? Because the entity to declare bankruptcy or in trouble is not the entity that owns the land. The entity that owns the land is a single asset entity, which happens to be a joint venture between another company that's solvent and an Ingle Homes entity. And remember, Ingle Homes isn't declaring bankruptcy or on the verge of bankruptcy. It's 2USA or whatever they call it, TUSA or something. Well, the problem is, if the parent goes bankrupt, it usually hauls in all the subs and all the single asset entities, and even if you get down to a joint venture, what is bankrupt is at least their interest in the joint venture, and we didn't want any part of that confusion, frankly, and vehemently they protested, but we held our guns, and I think appropriately so, and you can see what happened. Ironically, notwithstanding their representations that don't worry, the bankruptcy won't affect this piece of property, Mr. Lang informed me today that we received a notice from the bankruptcy court saying that we as a city are precluded from doing anything with respect to the water we supply to this project. It was an order of the bankruptcy court, so we must be tied in some way, notwithstanding the attorney saying we weren't. So those kind of considerations, even though they're not in the policy, and even though, during the good times you don't think of that, we often look at the bond issue with an expectation that things turn pretty south. And hopefully that protects us from some of the fringes of where we might get into trouble. I think, too, what we've tried to do is to present to you all more information on exactly what sort of burden this creates on the home buyer, because that may not be a financial risk to you or to city or anybody else, but it has some political overtones, certainly, when people come up here and pound the podium about how high they are. And so we've tried to present more information to you on what the effective tax rate is of the overall debt burden that we're placing on them through CFDs, through the city, through the county, et cetera. So there's an aggregate ad valorem tax rate that we present to you, and then there's a tax rate equivalent that we've been presenting to you as to when we do assessment bonds, these people have to pay X number of dollars every 6 months or every year, and if that were a tax rate, what would its equivalent be? I.e., if you had to levy a tax to raise that amount of money, what would the effective tax rate be? And so we've tried to show you that assessment bonds, you can't just examine in a vacuum. You have to examine as, okay, what kind of burden are we creating on these folks? And what kind of folks are they? To have a $17 tax rate or a $21 tax rate on somebody who can afford a $500,000, $600,000 house, that may be an okay thing. To do that on somebody in a $200,000 house where the payment is just $125 every 6 months, that may be devastating. And so you really need to kind of look at these in kind of perspective as to what you're doing to who and to where they're at probably in lifestyle, et cetera. And again, that's a lot of touchy-feely sort of thing, and very difficult to write in policies, but it is the kind of thing that hopefully we present it well enough that you can consider. We certainly have behind the scenes. So. Is there anything else? With that, I will answer any questions you might have or turn it over back to Larry.
Let's take questions for Scott right now, because I have a feeling if we keep going into the other arenas, more will. Yeah, no, go ahead. Fire away.
Okay. Scott, we have a proposal here from Louth. And in the development agreement, they state regarding public infrastructure contract and risk of loss, says here, as between the developer and the city, developer shall bear all risks, liability, obligations, and responsibilities under each public infrastructure contract, and all risk of loss or damage to any public infrastructure or any part thereof, occurring prior to the time of acquisition. Now, where is the risk then from the city's aspect in this statement?
Well, that statement talks about prior to, so prior to us owning it, we have no risk. But if they want us to finance it, then you ask yourself, okay, what's the quality of those bonds? Because you have an obligation to the bondholders to try to put a secure financing out there. You do not want defaulted deals. I don't care if they're in a CFD where you technically have no legal liability. I can tell you, at the very least, somewhat of the reputation of the city is at stake, even if a CFD bond went under. I can tell you that with you all sitting as the governing board of each CFD, which I strongly recommend because you don't want to turn it over. In a case of over 600 acres, you can turn it over to an independent board. But with you sitting as a CFD board, I know the SEC will have no trouble piercing the veil of going from the CFD board to the city. They did it in Pinal County back in those days of improvement districts Larry can tell you about. So there is a nexus between the city and the CFD. So for them to say, don't worry, the city's, and I don't mean, I'm not picking on them, I mean them
Right, it's
generically, to say there's no nexus between the city and the CFD, you know, that is maybe a technically, legally correct assumption, but in practice and in lawsuits, it doesn't happen. They come together, okay? So now what is the risk? In a case like a Louth, we would say, okay, number one, do we want a CFD on that? Well, it's a small number of acres. What is the assessed value of that property ultimately going to be? Because we now have to maintain a CFD which has administrative expenses, et cetera, and will a 30-cent tax, which is the max we can levy on under a CFD, support all its administrative operations, et cetera? That's one question. Number two, do we want a CFD that has budgets, et cetera, agendas, open meeting law issues created for what is a single-shot project, i.e. they want to build a water line down there and maybe pave a road. It can be done in one bond issue, et cetera. It's not an ongoing thing. It's a one bond issue deal. Whereas a CFD, as I mentioned before, and your policy state, it is not generally for one project type of thing. It is for master plan. It is for long-term. It is for multiple series, et cetera. So maybe that project doesn't fit into the CFD category. So what does it fit into? Well, it's remarkably similar to your business commerce center you did years ago, where it is a business park. And so you may want to consider an improvement district. Single shot type of financing, however, it comes with the contingent risk of the city being liable in the event the property owner doesn't pay. What you have in the Louth deal is a concentration of ownership, which is good and bad. It's bad in the sense that if they go under, the whole deal goes under. Okay? It's good if they're good. And if they sell parcel number one to person number A, well, and person number A turns out to be a flake, then person A goes into default and we have to foreclose on that property. It's exactly what happened in a business commerce center where the original developer wasn't the one who defaulted. It was the subsequent owner. So you can't protect yourself against that. But going into the deal, there's a concentration of ownership risk there that you have to disclose in the official statement. You also have, it's a commercial project. Commercial projects, you probably want to be fairly confident as to what the market is in that area. Is it going to be a success? Is the land going to, be capable of being developed and marketed, et cetera? So all of that being said, you shake it around and try to figure out, okay, there is an element of risk to it. Do we want to take the risk for what the rewards are? And the rewards are, and this is similar to the CFD. If a CFD doesn't finance the infrastructure and the project, there's a demand for the project, it's going to get built. The developer's going to go borrow money at a taxable rate, and they're going to build it. And the cost of recapturing that loan will be in the cost of every house, or in this case, the cost of every industrial lot. Versus they don't have to get financing from their lenders. It somewhat, in essence, goes off their balance sheet. It goes then to the public securities market. The public securities market invests their money via bonds in that project. And so public securities have all sorts of legal ramifications. I'm not going to scare you with all that, but they're serious. I mean, there's treble damages and criminal liability. But, again, we do the best we could on that. So will the project be done with or without it? If a developer ever tells you, I need public financing or this project doesn't work, then do not do the deal. Because that project, if it can't work with just that interest rate differential, it shouldn't be coming before you. That is way too risky. So I always caution developers when they're just about ready to tell me that, I tell them, be careful what you tell me right now because I will report it to council if you tell me that that is the thing that makes your deal work. That's insane. I mean, you don't want to be the lender of last resort. What you are trying to do is add an economic incentive to come to the city of Goodyear, not an economic weak spot where they can come and they can get easy money. So use it as an economic development tool. Don't use it as a lender of last resort. Now, none of that applies to Louth because I really haven't looked at anything. So I hope that discussion isn't taken in the context of Louth.
No, that's just one part of the thing that popped up when I was reading through the development agreement, and then we began stating where is risk in the long run, and so what you're saying is really be cautionary because of the uncertainty of the markets today about adding or going into any other CFD at this time.
Well, I think you want to be very cautious on any land-based financing, any land-based, kind of transaction. Not just during these times, at all times. These times just bring out all the problems that we should be thinking about, even during the good times. So, it's a nice time to have this discussion because, it's so vivid as to what can happen. But frankly, these similar concerns are there whether the times are good or bad. It's this kind of thing we think about when we do the deal, even during good times. And, again, we're accused of a lot of things like being way too conservative and that sort of thing. But it's a matter of how much risk do you think the government should take in order to add an economic development incentive for someone's project? And if your answer is none, you'd never do these. If your answer is, well, maybe a little bit because I understand it's inherent in the transaction, but I like what I see and I think it's going to be a success, then maybe you take some. If the answer is I want to be the lender of last resort, find a new bond counsel.
Thank you. Good point.
Very good. Very good.
I want to continue Scott's train of thought for 1 second. Can I take the liberty of doing that real quick? If I go with that train of thought on the commercial side, I feel pretty good. Why even consider a special assessment given your train of thought on the housing side?
Why?
Yeah, help me understand that, because oftentimes housing is looked at as an economic drain on a city or a municipality, and not an economic windfall that say a mall would be, or obviously the two are intertwined with one another, or the three, employment, commercial, and housing. But we understand why I might want to build a 20-mile road with a special assessment without naming specific projects.
Well, you wouldn't for a 20-mile road.
I guess.
But that's where you get creative and you think a different way to couple financing. There may be some assessment, there may be some GO, there may be it's an acquisition. We may issue GO bonds after development has occurred. You start to say, okay, I need to mitigate this risk. And how am I going to do that? Well, I'm going to make sure the risk stays with the developer until there's less risk for me to sell my bonds. And so me being me, you, us. So granted, each situation is unique, although not, there are some commonalities that flow through each and every deal. Why would you do it for residential? I think you do it because it takes rooftops to do everything else. And rooftops come, and then other things come that you really do want. And I don't dispute any of the models that show that residential is a drain because it's services and that sort of thing. You can fix that, raise your taxes, then it won't be a drain. But that's, again.
Say thanks.
You can tell I'm an economics major in college. I just changed the assumptions on you, that's all. But if you have a tax rate, and obviously you supply most of your municipal services to residential, and the tax rate on the residential is not enough to pay for those services, clearly it's going to be underwater. But clearly those same rooftops are the reasons why there's a regional mall here, and the reasons why there's growth coming and that sort of thing. So why would you do it? I think you do it in order to make sure you have rooftops. Do you want to do it forever? No. Is the time right now the time you stop? I don't know. That's your decision as to, okay, we've added enough incentive. We did them in 1989 with the city of Goodyear because we didn't have anything. And we had the core downtown. And, we were going across the freeway here in Palm Valley, and it was an economic incentive tool to utilize that allowed, we thought, the city to get some trade-offs as far as, a little upgrade in some of the infrastructure, to get a lot of the infrastructure built as opposed to scalloping down the streets, and just to be known as a community that is friendly enough to kind of look in that direction. So, did it work? Would they have come? Would they have built with all of that? I don't know the answer to that, and I don't know the answer when to not do residential.
Sorry, Frank, I trumped you.
Well, that's all right. I want to go back to your statement that you talked about doing one of these bonds early to acquire the funds early to get this development going. Back when you stated that sometimes these bonds are asked for early or acquired earlier than the development is ready, so that those funds would be available as the development is built. If that happens, is there interest due on that, and who pays the interest on that?
The moment the bonds are sold, there's interest due on them.
Okay, well then who pays it?
And there are a couple of different things. Oftentimes, or not oftentimes, but you can sell what's called capitalized interest. In other words, you sell extra bonds to pay the interest that comes due on the bonds during a period of construction. We in Goodyear rarely do that.
that's pretty
In fact,
dangerous.
I don't think we've done that for quite some time. But we don't do that because we do acquisition bonds, and capitalized interest is used to pay the interest on the bonds during the period of construction, plus 6 months. So you don't see us do that here because we do so many acquisition projects. Now, the question is, when do we sell? Do we sell bonds right now, knowing we're going to acquire a project in 3 years? And you're right, the bond proceeds sit. And there are, generally in those kind of circumstances, we'll get an agreement with the developer that says you will pay or you will accept an assessment on that property and pay so that we don't have to capitalize interest. Additionally, it's offset somewhat by investment earnings, but investment earnings are typically lower than what the bond yield is. So there will be a negative arbitrage difference there that needs to be paid by the
So it's not back on the city's back.
No.
The city doesn't have to pay that interest.
No, we would.
We haven't in the past.
Right, we have not.
But we haven't done much of that, have
The
we?
city it never has, and the CFDs never have. We've had pretty good success here.
Okay. Thank you.
I mean, the only defaults that I know of have been just recently some of these homeowners,
Sure,
Yeah,
a couple.
yeah, we heard about those.
Good deal.
Larry or Larry?
I don't know.
Thank you.
More questions? No, we're good. I'm looking at the clock, and it's getting close to 6 o'clock, and we have another individual that's driven in from downtown as well. So.
Yeah, I know that drive.
Yeah.
It's a little slow today. I'm Larry Gibbon, the city's financial advisor, and Scott's done a great job. Okay, and he's touched on all the things that I think that you really need to know ahead of time. So I'm going to give you some hair-raising stuff about what happens when things really go wrong. And the reason I'm doing this in a way is I think that the team that you've got here at the city you're very fortunate to have and have had over the last 5 to 10 years, to be conservative, because you may be well aware of some of the things that have come before the city of what developers want to do, and I think thankfully the staff is here to be the buffer for some of those things, but I can tell you a lot of them get to the point of Scott and I, and I'm not ashamed to say there's been a lot of developers storm out of rooms saying the council's going to hear about you or the manager's going to hear about you, and he's mostly talking to me because Scott is so eloquent, they don't realize who's telling them no. It might just be me, because I'm not as eloquent as him. But what can go wrong with things, what can really go wrong in these things? Scott's pointed out one thing, and that is the SEC. Generally, there's 2 places these deals can end up, and because of the time short, I'll just tell you a couple of experiences that I've had where the situations get out of hand. As one example, I would tell you in a CFD where you've got dirt supporting the deal, the economic situation turns, and again, you've got Force you've got some seasoned guys here who have been through previous real estate recessions, like in the early 1990s, which was the genesis of one of these examples I'll give you. What can happen is you've got developers sign on. It looks like a pretty good land market out there. You sign on for a rather large project in which there's a limited number of developers, which is circumstances have happened here, like with Estrella Mountain Ranch. And you see, over a period of time, you put assessments on this property to pay bonds, but over a period of a couple of years, things turn as they have, and all of a sudden these developers hit rocky times. And the example I'm going to just get down and tell you is the city of Chandler back in the late 1980s. I was their advisor, and they were doing some rather breathtaking financings with improvement districts in those days because that was the one tool they had to develop Ray Road and Warner Road. Some of those roads now that are so heavily developed, you'd never know that back in the 80s they were just farmland, but they were. And along came the real estate recession of 1989, 1990, and a lot of these families were involved, even the Dobson family and so forth. I was not to pick on them, they didn't go bad, but a lot of these farming families were involved in these development type deals where indeed the infrastructure was there, came time to make the assessment payments, and developers had come in and gotten loans to purchase these lands from these families and develop this property, and a lot of these loans came from savings and loans institutions. And the developers ended up going bankrupt because the economic times turned against them, and the banks, in turn, those savings and loans went bankrupt as well, as if you remember back in those days. And so now you're looking at circumstances, who's going to pay those assessments? Well, you run into one difficulty then. It's nice that we have the summary sale process which says, and I'm not going to talk about residential individual lots, I'm going to talk about major developments here today, because there's a lot of other bad things that could happen with residential developments, but it's nice to say we've got a summary sale process. Well, even in those days, we were covered 4-1 to go to sell the property. So what's the big deal? Let's go and sell that property in February whenever you can get that summary sale process going to make good on the bonds. Well, circumstances are that on December 1, their assessment's due. January 1, the city's got to pay. I mean, you guys may have gone over this. It's January 1, the city's got to make the payment on those bonds. We can't sell that property until February sometime, just because the process takes that long. What's going to keep our bonds from going into default right then on January 1? Might be a reserve fund, but in the example I'm going to give you, city improvement districts don't have reserve funds. You can't fund those. And typically, in the past, we haven't had those in some CFDs, I think, but we do now have some reserves to cover us for that period. Well, but this might be applicable to a future improvement district. Who makes the payment then? What do we do? Well, the statute allows the city to make the payment, to make a temporary loan, to make it so you can get past that rough spot just before you sell the property and go through some of the other problems I'm going to talk about. Well, that's one decision the city then has to make. And if you have a whole bunch of them go, a whole bunch of the district go into a default, even with a reserve fund, it's not going to be enough. So then you're hit with, what do you do then? City council say, well, we have no responsibility. That's a CFD. Just let them go sink. You know, we don't care. Everybody knew going in this is the way it was. I'll get into that in a second about where the SEC is not going to see eye to eye with that. Okay. So now you're into now you're into selling the property. So you've made that first hurdle, and you're going to make that payment just to keep these bonds afloat until we can sell that property, and everything's going to be okay. So then you go down. You made the payment, and you go in, and you can start to sell the property. You get a notice from the bankruptcy court saying this developer's in bankruptcy. You can't do a thing with this property until we have taken all our actions with all of this guy's debt. Well, folks, that's not a 2-month operation. That's more like a 3-4 year operation in the circumstances of major developers. And I've been through this, okay? And then you get the savings and loans on top of them, being bankrupt also, and there's another 3 or 4 year operation to unfold all that problem. So what do you do then? If you've made your loan, or if you haven't made the loan, you've made a decision, we don't want these bonds to go bankrupt, but heck, we might not be able to get this land out of bankruptcy court for 3 or 4 years. What are we going to do? Well, that's a tough call. I was faced with this in Chandler, all the way through to this, S&Ls were bankrupt too. And God smiled on Chandler because we made the decision, the city made a decision to make this temporary loan of an improvement district bond that was temporarily, had gone into default, but prior to the summary sale, the city said, even though the bankruptcy attorneys for the Resolution Trust Corporation, which came in, if you remember way back then, 18 years ago, was the government agency that was looking over all these S&Ls that had gone bankrupt, they come in and said, we're not going to let you sell that property no matter what, so just forget it. We're in charge here now. You guys are not in charge. We're now, you know. But we decided, the city of Chandler said, we're going to make that temporary loan anyway, and we're just going to, you know, let fly. And as it turned out, God smiled, and the Resolution Trust guys came in. Same attorneys called up and said, well, we changed our minds, and we're not going to let this thing go to summary sale. We're going to make the assessment payment, and we're going to continue to do that for all the improvement districts that are in default in Chandler. But let me tell you, what if they hadn't said that? You'd have 1, 2, in the case of Chandler, it might have been 4 improvement districts bankrupt, not paying bondholders. So your first stumbling block out of the chute is, if this is an isolated incident with one homeowner, that's one thing. But if you got a major developer out here like X, out in Estrella, X Mountain Ranch go bankrupt, what do you got then? You got a whole bunch of trouble. And that's really what I want to warn you about. And so that's why you got this hurdle up here keeping every developer from coming and proposing these things that look great. At the time, heck, 2 years ago, things looked great. And I'd go and talk to groups like your former finance director had me speak to finance directors, and I was like laughed off the stage when I was starting to talk about what can go wrong. And really, some of those guys are still around, and they even mention me now, well, you were right. Things can go bad, but that's because they haven't been through what we've been through. Let's get to the bankruptcy court then. In the case of a bankruptcy court, they decide what is I forget the terms now, Scott, for what is a general debt of the corporation, wherever Scott is, and what is the specific debt that has to be paid for this property. They may decide that the bonds are, I guess the worst thing would be the general debt of the corporation, and it falls way down underneath one versus the secured debt of this corporation. It's just a general debt that if everything else gets paid, then maybe we'll pay part of these debts. Well, we haven't been there yet, but you could end up there. So bankruptcy court's one thing, and they're not constrained by municipal law or even the Constitution of the state of Arizona. We were through another one of these things with irrigation districts in central Arizona back in the early 1990s, in which bankruptcy court basically changed the status of the GO bonds of these certain districts from being GO bonds to follow a certain statutory course. He decided they were revenue bonds, and that these districts could go bankrupt, and the Constitution of the state of Arizona did not apply. And so you got bondholders sitting out there saying, I thought we bought GO bonds. Some bankruptcy judge and a court in Phoenix decided these are no longer GO bonds. And Scott can back this up. I'll tell you one thing, it scared the heck out of our whole industry. Anybody who had a brain, well, what is a GO bond? And if some bankruptcy court can decide it's not, that's a pet peeve of mine. You can also go into a situation, I'll get specific, this will be my last example, of a circumstance out in Apache Junction since we're done paying that now, I guess there's no way to come back and get us. The Apache Junction had a circumstance where they formed a CFD to do sewer work. And I don't know if you know Apache Junction, but there's a whole lot of people at Apache Junction who never like the idea of having sewers put in. And it's a rough place out there. And I used to joke that if I ever went up to a city council meeting, I wanted chicken wire up in front of me. Just to, like those country western men, just to keep the bottles from hitting me when I suggest doing anything like that, okay? But that might have been a little bit in the past, but it's not that much different back in mid-1990s when the circumstances I'm going to tell you about. They wanted to do a sewer CFD, and our firm decided early on, we were financial advisor of the city of Apache Junction, we didn't want anything to do with this thing, but they were insistent. And so we said, well, we don't think this deal can economically work, notwithstanding chicken wire. It didn't bother me at that point, but this deal will not work, okay? And we sent them a letter saying, we resign, we're not going to work on this deal. We just can't see the way that it can work. So they went ahead and did it anyway without us, with a bond underwriter and purchaser of the bonds, which was, I think it was Allstate Insurance, Scott mentioned earlier. And lo and behold, the bonds went into default. Can you imagine? The deal didn't work. Well, the city decided they were going to sue us because, this is an SEC kind of circumstances too, but it's circumstances you can go to court. Remember, we resigned before the project even got on track, but a court decided that we were partially at fault for that deal going bad. And we ended up being socked with a $6 million assessment from the court because a jury of 18-year-old kids from Ray, as an example, decided that we were partially at fault. And the SEC can come in later and decide that too. An individual court or an SEC can come in and decide that this council made a bad decision and they should have known better. We don't care what the law of the state of Arizona says. We don't care what the CFD law says. We think you're partially responsible. And we think it might be 20%, maybe 10%. I forget how they divvy these things up. All of a sudden you're hit with a $6 million hit because some developer went bad. So I want to warn you that, when developers come to you and say, these guys are really being recalcitrant, they don't know what they're doing. They're being unrealistically negative about our project. Put some of this into your cap in the future when you hear from these guys, because this is the kind of stuff Scott and I have been through, and Larry has been too. It's been some of his past lives. He's seen a lot of pretty interesting stuff, and you have to have a little bit of trust in us. That from what we've seen going in, this might be a warning sign of what might be to come. With that, I'll just let you go, and I don't know if you have any questions, but that's.
I have more some do.
Okay.
But carried.
Generally speaking, go ahead. I'll start over here.
Okay, you mentioned the resolution trust. The resolution trust came in on Chandler's deal.
Yeah.
Now, in a case like this, if this should happen out here, would we have that to fall back on? Is that even in existence anymore?
Well, it wouldn't have any bearing at all in your case that the fact that they did it in Chandler, there's no longer a resolution trust, there's only some bonds that they issued back then to take care of. There's no longer, they'd have to form a whole new governmental agency if all of a sudden, since S&Ls really don't exist anymore.
I wondered if that did.
Yeah, so commercial banks would probably have to be the next thing that would go hit the rocks.
So they're gone.
But, you look back and you think this could happen again, because what happened with the resolution trust, I mean, what happened to S&Ls was Congress decided one thing, and next, 5 years later, decided something different, and all of a sudden all the S&Ls went bankrupt because they changed the accounting rules on them. So you just don't know what's going to happen.
Okay. No, thank you.
Sure.
Any other questions?
Other than, we appreciate you fighting the traffic.
Yeah, thank you for.
Yeah, thank you.
Very interesting.
Larry, are you seeking some common direction from us this evening, or do you have a question? that you
This,
pose
as
to-
we intended up front, was to give you some background. Obviously, if you wanted to give direction, that's fine, although we don't have specific application. We have the three that we are working on, and so we'll accept any comments that you may have, or else we'll just keep working forward and getting you the information as it comes to us.
I just want to say Scott Ruby has done a tremendous job. In all the years I've been on the city council, he's been with us, and his guidance has really led us a long ways, because I came into this council and I'm like, what the hell is an FDC? And here we are with, trying to get this all explained and going through this, and I know the new people probably still are, but it takes a while to adjust all that. And he's done a tremendous job in keeping us on the up and up, and we really appreciate Scott being with us.
I guess the burning question is how long we're going to be doing CFDs. I mean, after listening to this, as a city, you may want to look into that and see the ramifications.
I don't think the intent of the comments were to tell us that we need to turn that tap off completely. I think the intent of tonight's comments were that as we look at specific transactions and proposed CFDs, that we look at what we're doing, that we look at the risks, that we look at the benefits to the community, and we analyze it. And I do think that I will tell you that the CFDs, the first two that Scott described, north in the Palm Valley area and down in the Australia Mountain Ranch area, I think they really accomplished their objectives, and they're a work in progress. I think that the issues down south, Scott's very accurate on the challenges that we have of putting it together, but it's probably a tool that can help us accomplish that through a combination of things. So I don't think it's going to be as finite at that. The real point of the conversation more is case by case, we should ask that question.
And, Rob?
Yeah.
And I guess it all kind of boils down to something that Scott said a little bit earlier when he made the comment about how much risk are we willing to take for the economic incentive. Isn't that it right there?
That is
so we
correct.
will ask our questions, and hopefully we get to the bottom line.
That is correct. And
Okay,
in case there's
we're not
That's
experts.
in case there's any illusions with any of you or on the city council, as a staff, Sheila and I lean very heavily on both Larry and Scott to provide us guidance with their experience, both over the years as well as working with other cities and developments throughout the state. They are very integral parts of our team. They're very strong for that, and we appreciate that.
Anecdotally, when you're looking at this, how much are you including economic development in your discussions? Are they sitting at the table with you while you're making these decisions on whether to proceed forward or not?
On the industrial one that is
Or
proposed,
commercial.
economic development would be at the table. We've never done a purely commercial CFD before.
See, we've never done
Improvement districts, yes, but not CFDs only. And yes, they are definitely at the table in that dialogue as they belong.
Yeah, somebody's got to be in there given, I mean, in the PR world, where I often operate, an attorney will always tell you to walk out of that boardroom and never say a thing, and in the court of public opinion, we know that's horrible. And so I'm kind of thinking,
You need a balance.
weighting the risk versus the gain. I mean, while I respect the financial minds in here, I also want the aggressive kind of entrepreneurial mind sitting at that table that's balancing that out with you.
Absolutely.
Thank you.
So direction is kind of continue along status quo.
Just the way they're
Keep
going.
bringing the stuff back to us. Let's make sure we're keeping a diligent eye on the economics of the situation, and I will note that
That's what we've been doing.
you know,
Absolutely.
I think we're much more
Exercise
aware now.
caution.
Thank you very much.
Thank you.
Thank you for making the drive out this evening. On our CFD agenda, we've got reports, but I'm going to ask everybody to defer that to the end of the work session, and I'll adjourn